Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law, where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So welcome, everybody. Thank you for being here, and let's get into it. Let's see what questions we have. I'm going to try to go to the questions right away, get into it. Here's a question from Marquita. She says, had a sacroiliac joint fusion surgery on Monday, cerebral palsy, trip and fall in Publix over aisle obstruction, denied liability. What should my lawyer do next? Will surgery help prove liability? Question, and then value question. Right. So no, surgery is not going to help prove liability because surgery, it goes to damages. The fact that you need surgery is a type of damage that you have. But surgery will increase the value, right? Because let's say you didn't have surgery. They might say, well, you didn't have it, but you have the medical need for it. Like if you don't have surgery and you have no medical need for it, like doctors are saying, obviously you don't need it and you haven't had it, then it's worth like soft tissue money, right? Like 10, 20,000. If you need surgery, but you're not having it for whatever reason, you're scared or you're putting it off or whatever reason, well, now you have medical necessity for surgery. So that goes higher. That could be worth maybe 100,000, right? But then if you have the surgery, that could be the highest value of all because you need it and you've had it. And that could be like 400, 500,000 or more. So I remember, I think this was the case in a different state, right? Was it Alabama? So I think we did some verdict searches on it, maybe not on sacroiliac, but we did maybe on some back injuries like fusions. And from what I recall, there were some cases, right, in the six-figure range. So I would say at least six figures, but it could be even into seven figures, which would be, $1 million. It's possible. And in terms of liability, you just have to show that you were not at fault, like either get the video or if there's no video, you can have your own testimony that you tripped because of the aisle obstruction. You can get an expert, like a human factors expert, and they'll talk about the fact that it's known that when people are shopping, they're looking at the aisle, right? They're looking at, like, say, the different cereals, Captain Crunch, whatever it is, Rice Krispies, whatever. You're not looking at your feet, so they shouldn't have any obstructions there. If they had like a cart or any kind of obstruction that would make you trip, that's their fault. And and then in terms of what your lawyer should do next, I mean, if they're a trial lawyer, they should know. Or if you feel like they're not a trial lawyer, or if you want to know, you could always text me. I could do a search, and then I could send you, an email with the results, like whatever I find in terms of whether they have trial experience, settlements they've won, verdicts that they've obtained. I would just need their name, and it's all confidential. And if we chat, like if I call you, or it's always subject to the attorney-client privilege as well, so it's confidential. But I'm happy to help. I could do that for you. And Christopher is here. He says, "Hey, Arkady, just want to say how much we appreciate all that you and your team do, and hope you can touch base soon. Some developments have happened." Okay, yeah, no, absolutely. Sorry, this week I was a little busy because I just got in, and I know I was meaning to call more people. I did a few consults, but I was meaning to call more people, and I didn't get to because I was just a little busy. We had some depositions and some paperwork I had to take care of, and working on a few projects. But I feel like now the rest of the week should be more open. So I was glad I was able to do this live, and then I'll do a few more calls and get back in the swing of things, as they say. Okay. And then Jordy says, outside of pain and suffering and lost wages, what else can you put into a demand letter? Yeah, so no, you could put whatever the elements are of damages, right? So obviously pain and suffering is one. Loss of enjoyment of life is usually another. The way that you used to do things and how now you cannot. And that can be the things you love to do, right? Whatever you're passionate about, whether it's sports or playing certain games, going out dancing, it could be anything, right? Going out to restaurants, whatever you can't do. So it could be your passions, the things you love to do. It could also be people in your life, right? Of course, people have like close friends, family, wife or husband, kids, and things you can't do with them. So I would tell that story of the things and the people, really paint a picture of how it was before and how it changed. So you could talk about the impact on your life, like what changed, what was it like and what is it like now, right? What did they take away from you? Because if they didn't take much away from you, let's say you got into a car crash, you went for a few weeks and then got some massages. Okay, that's great. Now you feel the same as you did before. I mean, yeah, you had the inconvenience of going to a chiropractor a few times, getting your back cracked, but they didn't really take much away from you. So they'll give you like 5,000, 10,000, right? But if they took something away from you where you had, let's say, a fusion surgery, right? And now you have this metal in your spine. You can't move, you can't bend. And, movement is health. People associate movement with health. And now you can't move. Well, they took a lot from you. That should be worth much more. That could be worth millions. But yeah, I mean, you just have to look at the pattern jury instructions in your state. And usually the categories will be pain and suffering, loss of enjoyment of life. Some places you could even sue for things like inconvenience, emotional, like, emotional damages. Sometimes you could sue for that. Lost wages, of course, if you have the paycheck losses, you sue for that. You could also sue for future medical costs. And like I was saying on prior videos, very often when you are middle-aged, like this one client, he was, I think, in his 50s, early 50s, and he had one level fusion, back surgery on his lumbar, lower back, and just the future medicals that the doctor and the economist put together were like 2.5 million. Just the future medicals. That's one category, and when you add up all the categories, it's going to be much more. So yeah, that's basically the things you could sue for. And Aquatic says, how much is the overall most likely percentage that medical bills get negotiated by at the end of a personal injury case when it settles? Can you file for Medicaid while you have a personal injury lawsuit? And if so, will that affect your lawsuit? So yeah, so with Medicaid, I believe the way it works is if Medicaid pays for your treatment, that's the subject of your lawsuit, then they can claim a lien and you have to pay them back, right? But the likely percentage that medical bills get negotiated, it's going to be different in every case. There's not really a percentage. It depends on what the provider will take. So for example, let's say a doctor agrees to treat you for free on a lien or a letter of protection, right? But then at the end of the case settles, and now the doctor wants their money, right, for the treatment that they gave you. So it could be whatever the treatment costs. The doctor could say, look, I'm a physical therapist, $100 a visit. You had 10 visits, so I want $1,000, right? And it depends what your case settles for. If your case settles for like 100,000, he's going to say, well, I'm not taking any reductions. I want my 1,000 because I treated you for free all those 10 visits, right? But if the case settles for like 2,500, well, now you're only getting like 2,000. He can't take half your money, right? So he might say, okay, I'll lower it to 500 or whatever, So just, you have to negotiate that. It's always going to be different on a case-by-case basis. Okay, and then Only Pure, let me go back. Only Pure says, what would be a reason for the defense for the insurance company not to produce the policy limits? They have asked for more time. Well, no, there really wouldn't be any reason. They have to produce the policy limits. I mean, that's the law. In some states, like in New York, they have to tell you before you even file a lawsuit. Like we have insurance law 3420F, and they have to tell us. Like in New Jersey, I believe, when you call them up, they don't have to tell you. They say, well, they don't have to tell you. But when you file a lawsuit, then they have to tell you. So what's the difference? Filing a lawsuit just takes like 15 minutes. You press a button, the lawsuit comes out. A paralegal could do it. You file it, and then they have to tell you. So you're going to find out. If they ask for more time, the only thing I could think of is maybe there's some kind of umbrella policy, or they want to verify with their policy holder, the insured, whether or not that insured has excess or umbrella, and maybe the insured isn't responding to them. So they want to do their due diligence and do their investigation and find out and give you the proper answer. So that's why they ask for more time. But, it's hard to say, like, it's just a guess. Okay, and then Steven says, what are some of the settlements you've gotten for ACDF? It seems kind of a common injury after an accident. P.S. I emailed you. Thanks, Arkady. Yeah, so with ACDF, I mean, that's going to be the anterior cervical discectomy and fusion. That's a serious injury. That's a back surgery, actually, to the neck, the cervical, right? So the most recent one, we actually got $3.5 million. That was an ACDF case, the one with the slip and fall. We did some videos about that one. We had one recently for 2.2, but that was not an ACDF. That was a lumbar, lower back fusion. And then I think we had one recently for 1.5 million, about 1.5. That was also ACDF. So yeah, that's usually you'll be in the millions for that. It'll be pretty substantial. And JP says, I'm in Tennessee. Is it true that the at-fault party's attorneys have to disclose the insurance premium? Well, if you're talking about the policy limits, yeah, I think so. I mean, I'm not familiar with like Tennessee law, but I'm pretty sure everywhere they have to tell you what the policy is, right? Because if you're suing a defendant, most states, I think probably every state will have that rule that they have to tell you the insurance, right? Because you want to know, are you going up against a policy that's only 25,000, or do they have $1 million, or do they have $1 million with $5 million excess? You're entitled to know that. I mean, that's something you're entitled to. Like in New York, they actually have to tell you automatically. You don't really have to even ask for it, but there are multiple, like CPLR, that's the Civil Practice Law and Rules, that's like the law, the statutes. There are multiple provisions where they have to tell you, like what I mentioned, the 3420F, that's before you even file a lawsuit. That's an insurance law. That's like as a claim they have to tell you. But then in a lawsuit, there's 3101 and there's other provisions. Actually, I wrote a letter today, a settlement opportunity letter, and I think I put the provisions in that letter, so I could probably tell you what they are. But for New York, but yeah, they're pretty much the same. I think most places. Yeah, it's 3101F and 3122B, and so they have to disclose the limits like automatically. You don't even have to really ask. Okay, and then Kevin says, have you ever took a distracted driving case all the way to trial? Distracted driving, meaning like when somebody was like on a cell phone or something like that. Yeah, probably. I mean, I've done a bunch of trials. It's hard to say off the top of my head. I'm not remembering one that was specifically distracted driving, but I do remember a few cases where probably they were, because like one guy was a pedestrian, he got hit and he actually broke his like shoulder, his clavicle bone. And like, I don't know why they hit him. It was at night. I'm thinking probably the guy was distracted or on his phone. And there was another one where it was a 2-car crash that I did in the Bronx. That sounded like a distracted, it was like a rear end. It sounded like a distracted driving crash as well. So distracted driving, if they're on their phone or something like that, I mean, you want to get the cell phone records if you can, right? If they're on a call or if they're texting, if there's a way to get that, that would be maybe the metadata, that would be powerful, right? The other way is if you just testify, right? What people saw, like if your people in your car see, hey, the guy's on his cell phone, that's enough. It's evidence, right? Any kind of evidence is usually fine. And then Jonathan says, hello, Mr. Frekhtman, how are you? Question, why is my case delayed for mediation? Defense doesn't want to respond to a mediation or even answer the demand letter. Queens, New York, rear-ended by a truck back in March of 23. So it's delayed because of mediation, but they don't want to respond to a mediation. Well, a mediation, remember, is just a process where both parties, meaning the plaintiff and your lawyer and the defendants and their lawyers and the insurance company, all agree, and they show up, and there's a judge, and everybody agrees on who the judge will be, and you just kind of present your case quickly. Maybe you give 20 minutes, whatever, then they have 20 minutes, and you have a mediation brief. So you submit everything. It could be like 10 pages, 20 pages, whatever it takes, all your injuries, all your medical bills, photos, whatever you have. And you say, hey, I want like whatever, $1 million. And then they say, okay, no, we want to pay you 100,000. And you see if you can come to an agreement in the middle somewhere. Maybe you settle it for, whatever, 600,000. But if they just want you to come to mediation and then they show up and they don't give you a fair number, then it just busts. And then you just say, forget it. Or don't agree to even do the mediation. But if you're saying that the defendants aren't even responding to a mediation, then it wouldn't be delayed, because then there wouldn't be a mediation. So what you do is you just litigate the case. If you got rear-ended, file a motion for summary judgment, right? Because there's not an issue of fact to be decided by a jury if it's a rear end. Get a judgment. They have to pay 9% interest on the liability judgment, and just put it on the trial calendar once discovery is done. Once you've been deposed, you've had your examination before trial. That's what they call it in New York, a deposition, where they ask you questions. Once that's all done, put it on the trial calendar. Queens, fairly quick. Probably after you put it on the trial calendar, you'll wait another year or so, and then you'll have the trial. Then at trial, they'll either pay you more, or if they don't, you get it from a jury. But yeah, feel free to text me. I'm happy to chat with you about it. It's 347-566-9595. Here, let me put it in the chat as well, so you can text me. Okay, and then Aquatic says, if you were recommended for a surgery but could not get it because the policy limits would not permit it, and you find another defendant that is partially liable, can you then get the surgery? Yeah, I mean, of course. Are you saying because the policy is so small that there's no way to pay for the surgery? Yeah, I mean, if you have another defendant that has sufficient policy, you can then get the surgery as long as, the complaint is amended and the defendant is being sued. Now you have both policies in the case. I think that's fine. Okay, Only Pure says, I have submitted my tax returns to my lawyer as proof of lost wages. Is the defense allowed to request a copy from the IRS? Yeah, they are. They can get it from the IRS as well, right? Because if you put your lost wages in issue, it's called in issue, right? You put it in issue because you're claiming lost wages. So of course they want to verify, right? Because you could, Dr. F some returns, say I made 20 million last year. They want to get it from the IRS, like from the horse's mouth, make sure it's true, of course. They're going to, just like they would get your medical records from your doctor, not from you, right? You might have a copy, but they don't know if that's authentic or not. They're going to get it from the doctor. Same way, they're going to get it from the IRS. Yeah, you have to give them an authorization. And then Jonathan says, defense counsel playing games or a strategy. Yeah, well, I mean, if they don't want to do a mediation, they don't have to. I mean, it depends on what amount your lawyer is looking for, but it's fine. Just move the case towards trial. That's your path. You're on the, getting to trial is like the road you're on, right? You want to do depositions, finish discovery, put it on the trial calendar. That's the path you're on. That's the road you're on. That's what you have to focus on, right? And then when you get to trial, you have a jury. That's where they're going to give you money, right? You have to win it, or you could settle it. That's like a contract. Whatever they offer you, if you accept that amount, you get that amount. But mediations are just like attempts to settle. They just say, hey, let's try mediation. Let's mediate. Well, it's non-binding. You can mediate. You can go in there and say, I want 10 million. And they come in and say, we have $1. Okay, you tried a mediation. Didn't work. Or you could be closer. So if you're closer, then do it. But if they're not even like agreeing to do one, I haven't really heard of them not agreeing to do one. There must be a reason, right? You should ask your lawyer, what's the reason that they're not agreeing to the mediation? But not agreeing to a mediation doesn't delay the trial, right? As long as discovery is done and you're on the trial calendar, you're going to trial. So just text me. I'm happy to, if you give me your name, privately when you text me, I could look up your case in the court's public filings, review what's happening, then we can have a call, and I'm happy to, answer any of your questions. Okay, Devin says L2 all the way to L5, S1 with radiculitis, maybe radiculopathy, has been herniated, but none are bigger than 3 millimeters in Washington state. Would this be greater than 50K? Semi-driver does have a policy of 1 million. It's hard for me to say, but if you have herniated discs with radiculopathy, that's the radiating pain, right? Where it radiates down to your legs. in Washington State, it could be greater than 50K. It just depends on how you present the case, right? All these things like the overall impact to your life, whether you have lost wages, right? Whether you have future medical costs, whether you have witnesses about like what you were doing before, how your life has changed. But yeah, having all those herniations, that could be definitely worth a significant amount. And then if you see specialists and the specialists do some sort of pain management procedure, like a percutaneous discectomy, something like that, those, could even be $500,000 or more. So you could even get the full $1 million. It just depends on how the case is built up and who's preparing it and whether they're preparing it properly. And then Steven says, can the California fires impact personal injury pending in Los Angeles? I suppose, I think trials are still going in Los Angeles from what I heard. I know one lawyer actually, I saw on social media, he lost his house because of the fire. And then the next day he was on trial. He was posted that he's going to be on trial in Los Angeles. I think the trials are still going, but hopefully they get the fire under control. It's been crazy. And then Baby Boy says, hey, buddy, why my case taking so long? I had a hip replacement and a neck fusion over a year ago. All I'm doing is literally just going to pain management and I'm still waiting. So you had a hip replacement surgery. That's serious. And the neck fusions. You had both. So that's pretty serious. That's those could be big cases. That could be into the millions. So it could be taking long because it's a big injury and they're trying to get a big amount for it. So that could be one of the reasons. Yeah, it's hard to say, without it's hard to say. Okay, and then the hanger says, hello, I got in a major car with a serious injury, full wrist reconstruction, and 2 fender benders since then. Does that affect the case? No injuries in the 2 minor ones. Thanks. No, it shouldn't affect the case. Just make sure that you, make it clear that you weren't hurt, you didn't get any treatment, that they were just little fender benders. The only way it would maybe matter is if you did have some medical treatment or there was some injuries in the subsequent, in the fender benders, the 2 minor ones. Okay. I'm going to be right back. I have to step away just for a minute. I apologize, but I'll be right back in like 2 minutes. So let me, I'll be right back. Okay. Oh, okay, I'm back. Sorry about that. I just had to go outside for a second because someone was at the door. Let's see. Okay. So we did the hanger, right? The major car. Yeah, if you have a major car crash with a full, wrist reconstruction, those are serious injuries. I mean, the only way it would matter is if those two subsequent accidents, if there's medical records that your wrist got worse because of that, right? Because then they could say, well, your wrist isn't hurt because of, or was hurt because of the major car crash. But then afterwards, there are two subsequent ones that also hurt your wrist. So from that point on, it's not the fault of the original crash, it's the fault of these other crashes. But if you didn't even treat and you said it was minor and you didn't hurt your wrist, then it doesn't matter. If there's no injury, it doesn't matter. Okay, and then Kenzie says, 3 years I was rear-ended by FDNY. I had both knee arthroscopy, shoulder arthroscopy, lumbar discectomy, spinal cord stimulator. I took all the epidurals. How much is my case worth? Okay, so if you were rear-ended by the FDNY, as long as they didn't have their lights and sirens on, that should be a good case. Usually, rear-ended, probably it's okay anyway, but just if they have their lights and sirens on, you then have to show it's reckless, which is a harder standard, but you could still do it. And then all those injuries, I don't know where you are, like what county, but with all those injuries, I would think it's worth at least like $1 million, probably more than that, because spinal cord stimulator, discectomy, 2 knee and shoulder arthroscopies, that's pretty substantial. That's pretty serious. That could be definitely into the millions easily. And Devin says, I've done an injection and chiropractic work with MRI confirming this. Yeah, that's good. Having an MRI is important because that gives you the diagnosis of what the injury is. And injections, depending on the type of injections, can also increase the value. And RDOT says, what happens if I have gaps between years on my tax returns, either from working off the books and during the pandemic, COVID? How does that work out? Well, you submit if you're claiming lost wages, you just basically, you want to have a narrative, or you want to be able to have proof of what your injury was, or what your income was before you got hurt. So whatever that proof is. So if you have it through your tax returns, through your W-2s, 1099s, whatever it may be. It could be through your testimony. It could be testimony of your economic expert. But, if you have some gaps because of COVID or working off the books, I would just be honest about it and say, look, I didn't work then because it was COVID. Nobody worked, right, for some time because of COVID. So everything was closed. So yeah, just be honest about it and deal with it. Have your lawyer deal with it and craft the best narrative that you can with what you've got, and it should still be enough to get some lost wages. And then Dasani says, Mr. Arkady, what happens when your personal injury case reaches in the Supreme Court? So it depends on what you mean. I'm not sure, because if you're talking about, like, if it's in New York, the Supreme Court is actually the trial court. The Supreme Court is the court where you file the lawsuit in. So that would just mean the case is getting started, or it could go to trial in the Supreme Court. If you're talking about some other state, like maybe Texas, right? I think the Supreme Court is the highest court. So that would mean it's an appeal. Whatever happened in the trial court is already done, and now they're appealing it, and they're trying to revisit and see whether the decisions that the judge made were proper, or maybe they could be reversed and there could be some issues to go back on. So that's usually how it is in other states. And Melissa says, bad Uber car accident in New Jersey. I was a passenger. My driver got a ticket and was at fault almost a year ago. Been in outpatient since, but wrapping it up. TBI, PTSD. How much is it worth? Okay, so assuming if there's enough insurance, if you're a passenger, obviously you're not at fault. So if you have enough insurance and you have a real TBI with radiology, like diffusion tensor imaging, or MRIs, like 3T MRIs, and you have PTSD, and you have a neurologist and all the proof, that could be worth a lot. That could be worth into the millions, but you have to make sure that you have all of that medical proof, as well as the human story from like circle of friends and people who would talk about how you were before and how you are now, how your life has changed. But that could be very valuable. And Faith says, love your channel, took a fall. X-rays show no broken bones. Doctor declined MRI since initial X-rays showed no broken bones. Now in physical therapy, initial diagnosis is whiplash and knee sprain, but physical therapy doc can't say for sure since I did not have an MRI. Lawyer has statements from eyewitnesses who confirmed how I slipped and fell. Is this likely to be an open and shut case for the lawyer? What settlements have you gotten for slip and falls with physical therapy for treatment when the place of business is at fault? So yeah, I mean, it would depend on the injury. See, it's weird that they told you not to get an MRI because the X-ray showed no broken bones. It doesn't really make sense because an X-ray would only show bones, right? The X-ray doesn't show anything except bones. So if the X-ray showed no broken bones, that would be the reason to get the MRI, not to get the MRI. That would be the reason to have the MRI because the MRI shows ligaments, tendons, right? Everything else like discs in your spine, nerve impingement, right? Everything else. So it's like, it doesn't make sense for what they said, but if you didn't have it, maybe you could have it now. I don't know when the accident was, but if you, let's say you never have it, then it just becomes a case of whiplash and knee sprain with some therapy. You could still get settlement, but I'm assuming it probably is not going to be that high, right? Because it's just a sprain and you don't know what your diagnosis is medically. So it might be just a few $1,000s or something. So usually the MRI is kind of like the gold standard. That gives you the diagnosis. It tells you what your injury is. So you kind of have to have that. I don't know why I don't know what state you're in also, you know, because the value would depend on where you are to some extent. But yeah, I think that you could still be an open and shut case. You could still get some money out of it, and also it would depend on the liability, you know, for like why did you fall? What was the unsafe condition? What did they do wrong? Slip and falls aren't that easy in terms of liability. And then Jordy says, do you have to sign an NDA if you settle with Uber? You don't have to. I mean, they might ask you to sign some stuff, you know, confidentiality, but you could always ask, hey, if I'm signing this confidentiality, then I want, you know, more money if you want to do that, or you could just not sign it. Okay, Leonardo says, hello, finally on the final stage. Yeah, no, that's good. That's good. Usually like when you're on the trial calendar, when you're getting closer to trial, that's usually the final stage. And Jordy says, have you done any shoulder arthro cases? And if so, what have you settled for? Yeah, I mean, we've done a lot of shoulder cases. I mean, they really run the gamut. Like, I think I did some videos about shoulder arthroscopic surgeries. It depends on the surgery. If it's like just a shoulder arthroscopic surgery, normal one, and everything is fixed, it could be like 150, 200. It could even be like 300. If it's like anchors, something more involved, it could be 400. We even had one with, I think, anchors more involved. And it was a trip and fall on like a tread in an apartment building, but the tread, like, part of the rubber that was covering the step, you know, where you put your foot, like came off the step. So it was like a clear safety violation. And I think with that one, we got like 850. So it was a pretty good 850,000. So it was a nice one for a shoulder arthroscopy. Yeah. And then Baby Boy says, can you settle a case without doing depositions? Yeah, you can. But remember, if you're settling before depositions, it usually, it doesn't, not always, right? But it usually means that the other side has not even had a chance to ask you like what happened, right? Because that's the deposition. They ask you, well, tell me what happened. Where were you on the date of the incident? Where were you going? Where were you coming from? What happened? Like all this questions. And then tell me about your injuries. Did you go to the hospital? Did you go to the urgent care? Who treated you? Why did they treat you? What did you do? What are some of the things you're able to do before that you can't do now, right? They ask you all those questions. And it could take like a few hours and there's like a transcript of everything. But if they haven't even gotten to that yet, if they haven't even asked you that and they just want to pay you some money, I mean, sure, they can, but a lot of the times it might be low money because they don't even know what the case is about. I mean, they know what you told them in the lawsuit or in the paperwork you submitted, but they want to have a chance usually to chat with you and to find out from you, directly. That's usually what they like to do. Although I saw one case that I was actually involved in another state where, as soon as they found out who the trial lawyers were that were coming into the case before a lawsuit was filed, they said, "Oh my God, these guys are coming in here. Take all our money," because the guys are just like really good lawyers. They get crazy results, and they just paid millions of dollars right away just to not even have to deal with these lawyers. So that was before depositions too, right? So that's a different scenario. So it could go both ways. But I think, by and large, usually if they're settling without doing depositions, it's on the lower end. Okay, and then Burns says State Farm in Florida. Let me go back to the question. I think I scrolled down too far. State Farm in Florida in November tells my attorney that they are interested in a settlement, but I see that they've been putting mentions in like updated notice of answer interrogatories. Not really sure what that means. So they're interested in a settlement, but they've been putting updated interrogatories? Interrogatories are just like when they serve you with questions, like what doctors have you been going to? Maybe they want to update the medicals and then pay a settlement. But you'd have to ask your attorney because that's very specific, I wouldn't be privy to that. You'd have to ask your attorney. And then Secreting says, if you have over 100,000 in medical bills in a truck accident in New York, is it a bad thing to keep accumulating more truck accident, higher medical guarantees, higher settlement? So you have over 100,000 in medical bills already with a truck accident, and you're saying, is it bad to accumulate more bills? You're saying? I mean, unless you need it. I mean, I wouldn't get bills just to get bills, just to pad the bill, because the insurance companies are smart. They're like billion-dollar enterprises. They have all the data. They see through that. That won't work, and they'll actually use that against you. They'll say, "Oh, you're just trying to pad the medical bills, right?" And kind of like orchestrate a false case. So I wouldn't do that. But if you need the treatment, if the doctor says, "Hey, you need treatment, like it's really medically necessary," then go ahead and have it. That'll only help the case. And then Honeybee says, where do we ask questions? In chat? Oh yes, in chat, absolutely. In chat is good. I could just read it and answer it right away. And then Mose says, hi Arkady, 8 epidural injections in the neck and lower back, 1.5 years in therapy, neck percutaneous, 500K rear-ended in Queens. What is my case worth? Okay, so rear end is always good. 500 is a nice policy. I would see if they have any excess or umbrella beyond that. Sometimes they have like 500 with a 3 million excess. And very often, like I'm seeing it myself, attorneys don't even find out. They ask and then the other side doesn't respond, or they never ask and then they lose out on, like the one case, there was 25 million in excess that the guy didn't find out. It's crazy. So definitely find out if there's more. But if it's just 500 with 8 epidurals and lower back therapy plus a percutaneous, I think it could be worth the 500. I mean, we had a case in Manhattan, which is about the same in terms of a venue, right? Manhattan is obviously New York County. Queens is Queens. Queens is a big melting pot. There's a lot of different communities there. It's an Indian community, Spanish community, Chinese community. So you have to spend your time picking a jury because it's very much like New York. It's a melting pot. So you have to get the right jurors who are willing to allow for significant compensation. But in Queens, you could do fine. I mean, like we got 548,000 on a percutaneous in Manhattan. So I'm thinking in Queens, probably you can get the same, anywhere from 200-300 to like 500-600. I think that would be the range. So I think it's worth most of that money. And then Honeybee says, I had a trip and fall accident walking my dog at night. The sidewalk was raised 2.5 inches. And she says, ignore that. Okay. Well, I mean, yeah, if the sidewalk is raised, especially if it's at night, you can't see it. So that's an unsafe condition, so that you would sue. In New York, you would sue the landlord and they would be responsible. And those are good cases. I have a bunch of sidewalk cases. And then Russ says, hello, Arkady. Quick question. How long does a UIM claim take to close? Uninsured motorist? I mean, it depends. There's not like a set time. They're all going to be different depending on the discovery, the complexities involved. Just like, how long does a regular case take to close? They're all going to be different. So just because it's UIM doesn't mean that it's always going to be the same. It's not uniform, I guess. But yeah, I mean, I've settled them in a few months even. They don't have to take too long. It depends, right? Because if you have settled with the BI and now you're going UM against, let's say, your own policy, you can just make a phone call. Sometimes they just give you good money and you settle it. So it doesn't take any time. It takes like a day or two. But if they're going to go through the whole deposition process, filing the arbitration, the lawsuits, all that stuff, then that could take even years. And then Manny says, my lawsuit for my commercial truck accident got submitted last week. How long do I have to wait for the first? Will it take for the first offer or deposition? So you have a commercial truck crash, and when you say submitted, do you mean file the lawsuit? Usually they have 30 days to answer and appear, and then you would see the judge, and then the judge would make a scheduling order for like depositions and things like that. So it could take like a few more months to get to deposition, depending also where you are, right? Whether it's New York or another state, it's all going to be different timelines depending on where you are. And Amiri says, what does it mean when an attorney hired by a trucking company doesn't respond to a demand letter or communication attempts from plaintiff's attorney? Is that a strategy they deploy? No, I mean, it's hard to say, not everything has a meaning. Sometimes they just don't respond. Like it happens to me too. I send a letter and I think like, okay, well, they're going to pay me what I put in the letter, or they're going to pay me close. Maybe, I put 3 million. Okay, they're not going to pay me 3 million. It's not that easy, but they're going to pay me like 1 million. They're going to pay me something. And then they just don't respond at all. And then later we call and we say, hey, why didn't you respond? And it could be because they're too busy and they didn't even get to it, or they missed it, or who knows, right? There's a lot of different possibilities, but it doesn't really mean anything. I mean, as long as you're confident in your attorney, you have a good trial attorney, you should be fine. As long as they're moving the case. They could try another letter later on, or they could just push it towards trial. If they write the letter the right way, then, if they didn't respond to the first letter, well, then that opportunity is gone, right? Like the first letter might have said, hey, pay me $1 million. And they didn't respond. So that deadline is passed. So now it's not $1 million anymore. Now it's 2 million. So you're going to get more money. So it's, in that sense, it's good. And then Kevin says, I just answered my interrogatory. I'm ready for my deposition. Texas case has been ongoing for 2 years now and is on the trial calendar for 2026. Hope it could be sooner. Oh, that's good. So you answered that. You're on the trial calendar. So good luck. I hope you get a good result. And Faith says, how do I get a doctor to do an MRI if the first doctor, ortho, I saw declined to order one? ER just did an x-ray. The slip and fall occurred in Pennsylvania, according to eyewitness statements. Yeah, I mean, I would just see, maybe you could just get another doctor to say you need one, maybe like a physical therapist. But yeah, it's tough with a slip and fall, unless they're going to use your health insurance or a lien. MRIs could be expensive, right? Because they cost like $1,500. So it could be tough. Like with no fault, it's easier with car crashes because the no fault just pays for the up to $50,000. So you just get MRIs, if you're hurt after a car crash in New York. But in Pennsylvania, with a slip and fall, yeah, it might be you have to use your health insurance if you have it, or a letter of protection lien. But I would look into that. Maybe ask the ortho again. Tell them you're having pain. It's not going away. You want to know what your injury is. I would ask your lawyer and your doctor and see if they could set it up for you. And then Kenzie said, I had a slip and fall in Stop and Shop in Queens. There was water on the floor. No caution sign. I had shoulders and wrist arthroscopy. How much is my case worth? Yeah, slip and fall in a Stop and Shop. Actually, I had a bunch of those cases. I had a slip and fall in a Stop and Shop, but mine happened outside in the parking garage and also in Queens. And I ended up getting a nice result. I claimed that it was leaking, like it was like one of those roof garages that they have with a covered roof, but it was like dripping, leaking. I think we got 500 something on ours. but we had like an ORIF, open reduction internal fixation. You have a shoulder and wrist arthroscopy. I mean, 2 surgeries, I think it should be worth like at least like 150, 200, depending on who you have handling it, how they're preparing it. That could be a nice case. Actually, yeah, I'd be curious to know like which Stop and Shop, because I'm actually handling another case now against Stop and Shop. This one's in Long Island. And the same thing, like slip and fall in a puddle. So I'm trying to get as much information as I can. Sometimes I speak to like former employees who used to work there. I'm doing some depositions because it seems like these Stop and Shops are like dangerous. And they always like hide information. They don't want to tell you anything. Like our case, we asked for the video and they said there is no video. How could there be no video? It happened right near the entrance. So that means like, you know, when those guys come, like the Brinks guys, they could just take the money and or you know, there's no video of them coming or going. It's like mind-boggling. I think it's almost you know, incredible, almost incredible as a matter of law. But that's what they're claiming. So yeah, I'd be curious. Maybe text me about that. 347-566-9595. I'd be happy to speak with you about that. Okay, and then JRM says, good evening, Mr. Arkady. Love your channel. Great information. Oh, thank you so much. I really appreciate that. Yeah, thank you. And Faith says, according to eyewitnesses, I slipped on liquid after they repeatedly warned employees to clean up the spill. Oh, so that's good. You have noticed that. If they told the employees to clean it up, they knew about it, and then they didn't, and then you fell. That's a classic legal case. So you have a good liability case. I guess I can see if my PCP will order the MRI. It's strange the orthodoc declined. Yeah, I mean, sometimes they're more conservative, and so they decline to offer it. But, you know, you just have to follow up with that. And then Leonardo says, jury selection date finally scheduled. Okay, that's good. That's good. And JP says, my attorney is telling me that they don't know the at-fault parties' policy limits. They're saying in Tennessee, they don't have to inform you the limits. Is this true? Yeah, like, I don't know, like Tennessee law, you know, I'm not a Tennessee lawyer, but you're saying, I mean, it could be true as a claim, right? So that's like true in New Jersey, like I was saying earlier. Like in New York, you do have to tell even as a claim, meaning before you filed a lawsuit. But in Tennessee, you know, probably that's true also as a claim. But when you file the lawsuit in court, I doubt it would be true anymore, because once you're in litigation, that's one of the, just like they, you know, meaning the defendants or the insurance company, they could ask you for your medical records. If you say you have a herniated disc or a need for arthroscopic surgery, they're going to ask you for your medical records. The same way, when you sue them, you ask them, hey, what's your insurance? So they have to tell you. I would be surprised if they don't have to tell you ever. Like that would be really, I don't think that's possible. But I think you mean probably as a claim before you file a lawsuit. And that's true. That's true in many states. That's true in, like, I think New Jersey as well. So you just, the way to, you know, solve it is just file a lawsuit. It just takes like 10 minutes. You file the lawsuit, and then they have to tell you. And Tay Kizzy says, lawyer said deposition soon. I found my case online, and it says I have an ADR begin in April 9th. Is my deposition or mediation? No, ADR is usually alternative dispute resolution. It's kind of like a mediation. They try to resolve the case. So if you have that April 9th, it could be that your deposition is before or after, but you should just ask your lawyer. And then, you know, the lawyer should also prepare you for the deposition. That's important. And Marm says, hi, super lawyer. Thank you for your work. Can you do a video about hand injury verdicts? Yeah, sure, yeah, absolutely. I don't think I've ever done one about hand injury. I don't think I have. That's a good topic. Okay, I'll do one. I'll do a video about hand injury verdicts. I'll research that, and I'll do some videos about it. It's a good topic. Because hand injuries, if you think about it, there could be a lot of different ones, right? There's hand injuries with surgery. There's ligament tears. There's open reduction, sometimes internal fixation with plates put in. There's also like degloving injuries where the skin comes off. Those are really bad. So there's a lot of different injuries to the hands. And Jordy says, anchors will be used for a slap tear, had facial bruises as well. Is that worth more than $250? Yeah, I mean, I think so with anchors for sure. Like we just had a case with, you know, like I was saying, with anchors, and it was a premises case, and we got like $850, so $250. I mean, yeah, sure, I think so. Why not? And then Amanda says, Hi, Arkady. The defendants want a second deposition date after prolonging the first one. Is that right? A second deposition date. Well, did they depose you in the first one and just didn't finish? Because they shouldn't be entitled to a second one unless, there's a reason. They shouldn't just be entitled to a second one. I think they only get one deposition. So depending on what happened, it doesn't really make sense. They shouldn't be entitled to a second one. Like I said, unless they didn't finish the first one, or unless you mean they adjourned the first one, well then yeah, because then the second one becomes the first one. They never had the first one. And then Darwin says, hello, hi, how are you? And Big Phil says, car accident 2021, suffered herniated disc, lumbar had 3 epidural injections, microdiscectomy, percutaneous discectomy. I have an arbitration later this month in Bergen County. What happens next? Yeah, so you just go to the arbitration, you see like what the arbitrator is going to give you. If it's an arbitration, then it's binding. So it means whatever the arbitrator says it's worth is what you have to take. See, I don't like arbitrations for that reason, right? Because what if the arbitrator you get is a former defense lawyer or a former insurance adjuster, which a lot of them are, by the way. And then he says, it's not worth anything. It's worth $25,000. Well, now you have to take $25,000. There's nothing you can do. You can't appeal it. You can't. I mean, if he did something like really crazy, maybe you could file a motion like de novo, but that's really hard. That's almost never happens. So that's why I don't like arbitrations. I like mediations. Mediations, you just come to the table, you have a judge gives his or her recommendations, but ultimately you don't have to take it, right? So if you want like $2 million and they're giving you $20,000, you could say, no, thank you, I'll see you in court, and go to court. So if it's an arbitration, it must be either that your lawyer agreed to an arbitration, or the arbitration is the only way to resolve the case, meaning it's like a UM or some kind of uninsured motorist or some kind of, scenario where you have to have an arbitration, which that happens. I mean, sometimes it's unavoidable. But yeah, I mean, I think that's a good case. You have micro and a perk, so 2 different surgeries plus the epidurals. That should be worth at least a few $100,000. Good luck. Hopefully the arbitration goes well. And JP says, I've had L1, L2, L3, L4 injuries, 2 epidurals. Do you have any idea what my case could be worth? I mean, it's hard to say depending what the injuries are. I mean, if they're herniated discs, depending where it is, and what the liability is like. But epidurals, I mean, I've settled epidural cases just for like over 100,000. I think we had one for like 140 we got, just epidurals. I think now epidurals are coming down in value because so many people are getting them. And they don't really solve the problem. I mean, they are painful. They are a type of surgical intervention. They put a needle in there with medicine to numb. But then once the numbing agent wears off, if the disc is herniated and it's leaking and it's touching the nerve roots, well, then the pain is just going to come back, right? It doesn't solve the problem, which is like you do the epidurals, but if they don't work, then you got to try the percutaneous discectomy or something else. So usually that's how that works. But yeah, if it's just epidurals, maybe like it could be up to 100 or a little over 100. And then T. Kizzy says, got offer in August, but my lawyer filed a lawsuit in September. Defense lawyer sent a defense denying injuries and liability. But how could you deny when you already offered me $23,000? All right, well, that's pretty standard because, it's like you got to understand it's 2 separate things, right? Negotiating a case is one thing. They could offer you money, but when they're litigating a case, right, officially they're going to deny. Because if you're saying, hey, they were negligent and they agree, well, then they lost the case, right? They can't win now. So that's every case is like that. Even big cases where you're going for like 3 million or even 10 million, they're always going to deny everything and they're going to put up a defense. But then during the trial, while you're fighting, they could say, hey, take 1 million, take 2 million, take 3 million. But they're not going to admit everything that you're claiming because that's just the nature. It's an adversarial process. You're like going against each other. So Manny says, can I ask my attorney how much is a lawsuit money-wise? Yeah, of course. If he's your attorney, he would be the best person to ask. He'll know the case intimately. So you ask him or her, and they'll tell you what they feel it's worth. Kevin says, hi, Arkady. Can I ask what is the average win rate for an attorney in a lawsuit? I mean, it's hard to say, right? Depends on the case. But I would say generally, most cases do settle. I would say 95% settle. So if you consider a settlement is a monetary compensation, so that's a win, because you wouldn't settle if you weren't happy with the amount, right? The reason you settle for X is because you want to get X. So if they offer you a settlement of 100,000, you know, hey, I'm signing this paper, and in 30 days I'm getting 100,000. So that's a win because it's like a contract, it's like a deal. And then if you go to court, it's probably depends on the case. I mean, some cases obviously go and you have defense verdicts, and other cases you have plaintiff verdicts. I mean, I don't know the statistics. I know med mal, for example, they say most are actually for the doctors because it's hard to win med mal. But regular PI, I would think, depends on the venue. If you're in a good venue, like let's say the Bronx or Brooklyn, most could be for plaintiffs. If you're in a harder venue where people are more conservative, it'll either be the defense verdicts or it would be lower amounts. And here's a question. Hi, Arkady. Rear-ended by Amazon van. Lawyer will be sued between shipping company, insurance company, or Amazon. Oh, you mean who your lawyer will sue? Well, they have to do some research to see what kind of van. If it's a delivery service partner, DSP, they could sue Amazon as well, the parent company, as well as the DSP, because I believe Amazon still has control, and they still, you know, have supervision control over the DSP drivers. So I would sue the main company as well. They have a lot of the money. There's actually some CLEs about Amazon I saw. I didn't get to watch all of it. I have to go back and watch it. But there were some nice cases. I did a video maybe this was like a year now, but there was a case. I think it was either North or South Carolina, and somebody got a big verdict against one of these Amazon DSPs. It was like big, like 40 million. And then there was another trucking lawyer that I actually worked with on a case, and we worked on a case together. We got like, I think, was it 3 million together? And actually he did this continuing legal education where he teaches on how to do these Amazon cases. So I think there's a lot of them going on. So yeah, you make sure you have like a truck accident lawyer that knows how to do these trials of these cases, because they're like a very specific type of case. And Carlos says, wait, let me go back. Carlos says, could a case be worth more depending on the negligence of the at-fault driver? I mean, yeah, it could be. I mean, you got to understand, like, jurors are just people, right? Like your neighbors, people, just people from the community. So sure, if there's more negligence, if the person did something really, really bad, really, really, you know, menacing or reckless or even like careless, where the jurors would get mad, how can you do that? Then they might think, hey, this is worth more money, because they just get mad at him for doing that. So it's just human nature. And then Marm says, sorry, broken hand in a construction work verdict. Oh, okay, that's what you mean, broken hand construction? Yeah, I mean, I could do that. Construction cases are going to be worth more than normal cases. I had actually a case like that in the Bronx. I had a guy who was doing some work and something fell. They were building a big building, like some kind of city building, and something fell that was being like hoisted up, and the chain broke and it fell and it crushed his hand. But he recovered fairly quickly. Like, you know, the bones got healed. He went back to work. And I think we settled it for about maybe 300,000, something like that. It's a few years ago. But yeah, depending on the nature of the fracture and the overall, the overall effect on your life, on your hand, on your function, on your ability to move, the overall injury, that's what you want to look at. Amanda says, thank you. And yes, the first one was completed and they said they needed a second date to continue. Oh, okay. So they probably just didn't finish. I mean, in New York, they only have 7 hours, so they can't really depose you for more than 7 hours. But in other places, perhaps they don't have that rule, so they could depose you. But it's kind of stupid. Keep you there for like 2 days, and by the time you just get so tired, it's like, okay, just get me out of here. You know, it's like, come on. That's not really what a deposition should be. And Digital says, hello, Arkady. If your neighbor's town home catches fire and spreads to your house, causing a total loss, can you sue the neighbor for negligence or just leave it to insurance? Well, I mean, if you were to sue the neighbor, you would still be suing their insurance, right? Because the neighbor is not like, unless the neighbor's like, Elon Musk and he's got money, you're going to be suing the neighbor, and the neighbor on their home has insurance. So that insurance would be who hires the lawyer to defend your lawsuit. So it's the same thing. Now, if you have that kind of coverage on your insurance, I guess you could just leave it to the insurance if they're paying. But oftentimes they don't pay, and you do have to sue. And also you would have to show, I guess, that it caught fire because of their negligence, did something wrong. But yeah, that could be a strong case. I've done some of those property cases. I think one was not necessarily a fire, but like somebody was working in a building in Brooklyn, and because they were working so close in the wall, because the buildings are attached a lot of the time, they damaged the other building, and then the foundation too. They damaged the other building. So I think we settled that for like a few $100,000 because we could show through a construction expert that, hey, you guys damaged the building. Okay. Rigo says, can you talk a little about car insurance denying the right to submit a written statement and saying that because I was also covered by them, I needed to give her a recorded statement. Thank you. I mean, you don't have to give a recorded statement. You could just say, I don't want to, and that's it. What do you mean? Oh, because it's the same company? Like, say you have Geico and they have Geico, and they're saying, I mean, I would just get a lawyer and have the lawyer advise you. It depends on the what the statement is. If it's just a statement about what happened, you can answer those questions. I mean, sure, you have to give your insurance company notice about what happened, right? If you don't tell them that you were in an accident, then they don't have to pay it. But if they start asking you about like your medical treatment or how you're feeling, if you don't feel comfortable answering some questions, if you're not sure, you could have a lawyer prepare you so that you answer those questions properly, so then they cannot use those answers against you later. You don't want that. And then Manny says, 2 ACDFs, rotator cuff, truck company has more than 10 million insurance plus more umbrella. Can I get the max? I mean, yeah, if it's a 2 ACDFs with a rotator cuff tear and it's a trucking company with 10 million, yeah, definitely, absolutely. I mean, ACF is a really serious injury. If you had 2 of them, that could be into the millions easily. Jordy says, do most of your commercial business cases settle or go to trial? I mean, I think most do settle. I mean, I think anybody, in most cases, are going to settle, but the way to get them to settle for the maximum is to prepare them for trial. So if you prepare them for trial, then they're going to settle for more, And if they don't settle, well, then you're ready to go to trial and you can make them pay more. But if you can't like rely on a settlement, you can't just like not do any work and just think like, oh, I'm not going to prepare for trial. I'm not going to do anything. It's just going to settle, right? Then you just basically ask them to just give you money. And they can call you on your bluff and say no. And then you're kind of like in a bad place. And Ice Cold says, can a 100% fault motor vehicle accident shift the case from New York no fault to negotiations or trial? 100% fault shift the case from no fault? No, I don't think so. I don't know. I don't know if you're understanding what no fault is. No fault doesn't mean that it's just called no fault. No fault just means that the car that you're sitting in pays for all your medical bills up to $50,000. It's also known as personal injury protection or PIP. So it just means that, like, for example, someone is in a car and they're at a red light and they're stopped and they've been stopped for like 30 seconds and another car comes and rear ends them. And so the car that stopped, let's say, has Allstate, but the other car that rear ends them has like State Farm. It's going to be Allstate that pays all the medical bills up to $50,000. So it's just like medical insurance, like health insurance. That's all it is. It's not really like no fault, like they don't care who's at fault. It's just they call it that for I don't even know why. I guess because they don't care who's at fault. It's the car that you're in that's going to pay all your medical bills. So that's how that works. And yeah. So. Yeah. apologize. There's somebody at the door again. Let me be back in 1 minute. Maybe I'll finish up these questions and I'll be all done. Okay, 1 second. I'll be right back. Oh, okay. I'm back. Sorry about that. So let's see. Which question were we on here? Let me go back up here. We did the one with the no fault one, right? Yeah. So no fault is more like just health insurance. So like, yeah. So in that example, they say they don't care who's at fault because it's the car you're in that's going to pay all your medical bills up to $50,000. But you're still going to sue the at-fault car that rear-ended you for your bodily injury, for your pain and suffering. But in order to obtain that, you have to show a serious injury. And there's like 9 different categories. It gets a little complicated, but you could usually show it as long as you get treatment and you have like your range of motion is limited. Let's say normal range of motion is like 90 degrees and you have 70. Well, that's a 20-degree limitation. That's usually enough, along with MRIs and proof of injury. Okay. And then 2NNY says, good afternoon, super lawyer, rear end, Manhattan, 100% the other driver's fault. 3 cervical herniated, 2 low back herniated, knee tear, 2 pinched nerves, Manhattan, 9 months, physical therapy, 2 epidurals, 20 acupunctures. Thank you. Yeah, so I mean, that's a good case. If you have enough insurance, that could be worth a lot because you're talking about pinched nerves, therapy, epidurals, acupuncture. Yeah, I mean, it could be worth a good amount. It could be like 5 or even 6 figures. Could be a serious case. And Mighty says, my case is almost to trial 3 years later, 2-level fusion, still not back to work, railroad worker. Do you think it could be a good case? Yeah, I mean, definitely. Fusion it's a 2-level fusion. That's usually going to be a large case. Plus, if you haven't been back to work, you have lost wages. So it could be a large case for sure. And then Hassan says, I have 3 epidurals and 3 foot microdiscectomy, shaved some bone off the disc, microscopic debridement, and tendon secondary repair, 6 months of physical therapy, 6 months mental therapy. No, I'm sorry to hear that. That could be a good case again. And Amanda says, yes, this is in New York. Okay. And then Manny says, thank you. And Tay Kizzy says, you told me my lawyer didn't have any verdicts. Could it be because companies don't want to go to trial with him and my lawyer firm, or is that suspicious and he's probably not a trial lawyer? It's hard to say. Like sometimes people have trials and they don't get reported, but usually you would think, somebody would report it, right? Because if it's like a few of the different databases, if you check like, let's say Westlaw, Lexis, if you check like verdict search, you would think like if it's a good verdict, right, like $1 million or more, then the lawyer would want to report it because it's like, hey, I got $1 million verdict, right? Come to me, I'll get $1 million for you, right? That's the idea. So it's like advertising. And if it's a 0 verdict, but he went to trial, well, at least he tried. But then the insurance company will want to report it and say, look at us, we're so strong. This guy tried to go up against us asking for $1 million, and we got 0. We gave him 0 defense verdict, right? But they would report it. But if it's not reported, then it's hard to say. I would say like if he really is like a trial attorney where he's done a lot of trials, it's unlikely, right, that he's not going to have any reported verdicts. But on the flip side, I mean, I think it's possible somebody could be doing like 2 or 3 trials and they just never got reported. That's possible, I suppose. Ice Cold says, sorry, Arkady, my question was worded incorrectly. Can bodily injury settlement exceed the standard $25K New York minimum if the professional bus driver showed negligence? Yeah, I mean, of course, bodily injury, I'm not sure I'm following the question. Can it exceed? I mean, it's going to be whatever the policy is, right? So the 25 is just a minimum. It can't be less than 25. But if it's a professional bus driver that hit you, the bus usually doesn't have 25. The bus usually has $1 million or much more. Or if it's a city bus, then it'll be just the budget of the city. So yeah, of course, it could exceed 25. Let's see here. Digital says, hope everybody is doing okay. Hang in there. I am 2 months ACDF post-op and getting closer to settlement. Oh, awesome. Congratulations. Yeah, I mean, that's tough. ACDF is a tough surgery. It's a lot of pain. It's difficult, but that's good that you were able to overcome that and recover. And then you're going to get a settlement. So, I mean, that's the best thing they can do is give money to compensate you, to try to compensate you. Right? The idea is to give you money to put you back in the position you were before, but like you want your health. You just can't get it, unfortunately. It's a horrible situation. And then Ice Cold says, well wishes and prayers to everyone dealing with motor vehicle accidents can take a toll on you mentally. Yeah, for sure. It's very difficult, unfortunately. It's very difficult. But I'm here to help. Like if you want a private consultation, just text me 347-566-9595. And it's, like I said, private and confidential. I'm happy to chat and help in any way I can. And all the best. Okay, everyone. Thank you so much for joining us today. Please like and subscribe to our channel. Let us know what questions you have. Let us know what videos you want to see, and we'll make those for you. All the best to everyone. Stay safe out there. Best of health to everyone, and all the best. Have a great night. Bye-bye.